Good morning to you.
Good morning. How are you?
I am well. I hope you are too.
Good. What am I going to respond to?
Godfred Adami's article. Have you read it?
Yeah, I've read it.
You've read it?
It's denial that the notice of appeal came to his attention.
Yes, that I did not know anything about it.
How can the Attorney General say this? In fact, Dana Akufo-Addo did this country a great disservice by appointing Godfred Dame as the Attorney General. Great disservice. How can an Attorney General tell the people of Ghana and the whole world that he didn't know that a notice of appeal filed 7 months before he left office did not come to his notice? I mean, yes. And then that notice of appeal had a recipient address or respondent's address. And that notice of appeal was filed at the registry of the court. Can you imagine?
But he said it's bailed out by the complaints from state attorneys later in April 2026, who say they also didn't know anything about it until they come with a directive.
It cannot be bailed out by the state attorneys. I mean, they are reading the letter upside down, or the notice of the notice to have some of the exhibits included in the record of proceedings. Attorney General had gone to court to say that exhibit AM1 and AM2 were not part of the record of proceedings, and that they wanted it included. And they said that this particular process that they are presently engaged in came to their attention only recently. That doesn't mean that the whole appeal process, because if the appeal process were coming to their attention for the first time, they knew what to do.
So you're saying there's no way he can say he didn't know about it?
My brother, it's not, you can appeal is not just going to the chief's palace and the chief passing the judgment against you in the court, in the chief's court. Then you go back and the next day you say, chief, you have to reconsider the judgment, what you said yesterday, and then you invoke his jury. No. The system doesn't work like that. So a lower court passes, hears a matter, delivers a judgment in the matter. The person aggrieved by the judgment, in this case, Sednam and his lawyers, Sednam actually, has a right of appeal. And anybody who does a criminal case emerges victorious, any prosecutor who does a criminal case and emerges victorious will, for 3 months, be expecting the accused person to appeal. He should be expecting it. Unless it's a strict liability offense. You should be expecting it. Then you just finish the criminal case and you go to sleep. I mean, it doesn't make sense. That's the first thing. The second thing is that when the appeal is filed, because the Court of Appeal is a court of record, the appeal, the processes that went on in the court below will have to be settled. And I'm using the word that is used in law. Settled. Settled means both parties, the prosecution and the accused person or their lawyers, will meet to agree on the documents or processes that will be transmitted to the Court of Appeal for re-evaluation. That's the appeal. So you settle the record. And the registrar will not settle the record if there is no no proof of service on the motion inviting or the notice inviting the parties to settle the record. The register will not settle the record. So are they also saying that the notice directed at the parties to appear before the registrar and settle the records did not come to their attention?
That's a claim he is making.
In the Attorney General's office, probably we need to re-examine the Attorney General's office.
Because he says that even if there was a notice of appeal filed in 2024, no further steps were taken on it until 2026.
It's not true. It's not true. So when was the record settled?
In fact, he says that the state attorneys had to raise an issue in court before they were given the records of appeal, which they realized subsequently there were some missing.
So how did they get to court? How did the process reach them?
According to his account, it was from the directive of the Court of Appeal.
But everything comes from the registry of the Court of Appeal or the High Court. It doesn't come from settlement lawyers. Everything, all the processes, will have to come from the registry of the court. Either the court below, when the appeal was filed, and the appeal has to be filed in the court below. The settling of the record of proceedings has to be settled in the court below. Hearing notice, when a date is fixed for the hearing of the matter, that counts from the Court of Appeal. So, what is it? All this is happening. And another Court of Appeal, here a registry of the Court of Appeal. So how can you, they're just running away from their own sloppy, defective, and compromised trial. It's so embarrassed by what happened that he's trying to find red herrings and escape routes.
A red herring.
And I have said that probably the state will have to go back and look at all the prosecutions of Godfred. All the prosecutions that took place when Godfred was Attorney General.
What will be the basis for that?
So, the Court of Appeal in the Atu, Fosun, and another case, and that other person was Japa. The Court of Appeal said that the submission of no case made at the High Court ought to have been upheld. If simply put, that the prosecution had not discharged their burden of proof. Proof here, burden of providing evidential material or providing the ingredients of the offense for which the Atu and the Japa had been charged to compel the defendants Atu and Japa to open their defense. He objected that he opposed the application for submission of no case. The court ruled in favor of the Attorney General, and at the Court of Appeal, the matter has been overturned. There is a civil case in which again, which came before Asia Buchi, and the Court of Appeal has overturned that. So we need to look at all the prosecutions that were conducted, and you see elements of what happened in Suriname case, in the Atu case. You see elements, or in the Opune case, you see elements of concealment of evidence, elements of over overzealous ambition to jail the accused persons, where the Attorney General is not interested in the justice of the matter, but only in securing conviction, where the Attorney General becomes a political animal pursuing the political opponents, not interested in the justice of the matter. You see elements. Look, certain case, the Kantukamantu market disbursement. Evidence was on file during investigations that the market women who suffered, or the market people who suffered the consequences of the devastation, the inferno, the fire, had been paid, has been given some support. The the first one was the investigator who investigated the matter, found as a matter of fact that all the people who were said to have benefited from the disbursement of the fund acknowledge receipt of the funds. That was contained in his report. Maslow contracted Balfour Ewa Onko, and they did an audit, and they also came to the same conclusion. So there was collaboration of that evidence. What did the Maslow and Attorney General do? They concealed that evidence. They concealed that evidence and still presented evidence and still presented the case as if the people had not been paid, had not been given money. When in fact and indeed there was evidence that they had been paid. That's concealment. So you see that the Attorney General was not interested in justice. He was interested in conviction. And I'll give you many examples. The 500,000. It's unfortunate that the 500,000 is lost in the middle, and that's why I support Oliver Bekavemo's claim that he will initiate action and civil action to recover the money for the state. In all this conversation, the 500,000 is lost. And who caused the loss? Maslow and Attorney General. Maslow and Attorney General.
How?
Maslow says, and that's their narration, that when Sedinam Tobacco gave out the 500,000 as an investment support into what's the name of that company? Ubatampa. Subsequent engagements indicated that Maslow was demanded 24% interest. Ubatampa refused. That narration cannot happen. The terms of an agreement must be settled before any disbursement can be made. It's common reasoning. Is what is the prevailing practice anywhere, that the terms of an agreement must be settled before any further step can be taken on that agreement. An agreement must come into being before any other step on the agreement can be taken. How do you say that Maslow gave Obatampa 500,000 Ghana cedis, after which Maslow then demanded 24% interest? How can you say that? And that is the narration they give to us to convince us, gullible Ghanaians as we are, that Saddam did something terribly wrong, because they know that this is not how things are run. And Saddam issued a Maslow check, and the Maslow check is not issued by Saddam herself, but the loan department who will satisfy themselves that all the boxes have been checked before they will issue a check. The Attorney General wants us to believe that when they issued the money to Obatampa, subsequent discussions led to the repudiation of the agreement. And Sedna, who did not use a personal check to give the Obatampa money, agreed to accept the money in cash. Granted that that was the case. They said they brought the cash to Bachuna. No witnesses. No witnesses. And they want us to believe this cock and bull story. And then they said Suriname wrote a letter to Obatampa acknowledging receipt of the 500,000 on a Maslock letterhead. And the letter was a photocopy. I guess if you are writing a letter to acknowledge receipt, the original must go to the recipient, not so.
Yes.
They found the letter, made a copy, a photocopy of the letter. Supposedly made a photocopy of the letter, but could not produce the original. 3. While Sedna was still in office, she was writing by her hand to Obatampa to demand interest on the 500,000. While Sedna was in office, and there was evidence to that. How can you say somebody has written to acknowledge receipt of money and still be writing to you for interest payments? Thirdly, when her successor took office, she also wrote for the interest to be paid. So the money is sitting on Maslow books. But Attorney General, who was interested in conviction, discounted all this evidence and said Sednam stole the money. And the burden of proving that she stole the money, he didn't establish. The court shifted the burden onto Sednam to show that she didn't steal the money. That's how criminal trials are done. They just frame the issue in the negative, then you think that you have shifted the burden of proof onto the accused. I can give you many examples. The 651 million, the vehicles. There's a letter from the Minister of Finance to PTA saying that the Minister of Finance has committed government to, we call it a letter of commitment, committed government to pay in for the vehicles. They were not interested in that letter. The company's explanation that the vehicles, the price at which the vehicles were being sold to government was different from the open market value because the open market value is payment by cash, direct payment. But this arrangement was to allow government 2 years to pay back the vehicle. And 2 years means that they are loaning the money to government in simple terms. So they have to charge interest. And when you add the interest to the market value of the vehicle, you get to what the price at which they have sold the vehicle. They said Serena had no authority. They discounted the Minister of Finance letter. They discounted the company's letter. They held Serena responsible. Meanwhile, Serena did not pay a pesewa for the vehicle. Her successor at Stephen Amwa went back to the company, renegotiated the price at which the company was selling the vehicles to government, and the Minister of Finance paid for the vehicle. How much Stephen Amwa renegotiated the vehicles for? Do you know?
No, tell us.
Carson told us how much Stephen Amwa negotiated the vehicles for. So now you are a journalist, you might know. But they're not interested in that. So they framed up Suriname and put her in jail. Suriname was smart enough to realize that the way the prosecution was going, she was not going to get justice.
Well, there's a...
The two people, Suriname and the director of operations of the Prosecuted. And let me just add the third one. They said she had paid herself ex gratia without authority. The finance director came to court to testify, the prosecution witness, and said she was entitled to ex gratia. The documents that she presented were documents upon which we worked out the ex gratia, her appointment letter and her terms of conditions of service. We didn't work out the ex gratia in a vacuum. This is evidence that is on record. And that Suriname was entitled to the amount that she was paid based on the letter of appointment and her terms and conditions of service. It's not Suriname who said that. It's the director of finance who was a prosecution witness. So, are you getting the head and tail of this man? Meanwhile, she was charged. She was convicted on paying herself ex gratia without authority. The man says, the director of finance says, I paid the extra. I authorized the payment because I had seen the documents that entitled her to that. And I was satisfied that she was entitled to ex gratia. He said, no, not justice, conviction. Daniel Azim, who was convicted and sentenced to 5 years, do you know that he's on bail?
Yes.
Why? The Supreme Court looked at the judgment and saw that there was merit in Daniel Azim coming out of jail and pursuing the appeal.
I see. But Godfred Dami is saying that the accusation is just...
I don't put Godfred Dami as the center. I don't have faith in Godfred Dami.
Yes, but you are saying...
him at the center at all.
But you're saying that there are some cases that he pursued.
Yes.
That we need to go back and take a second look at.
Yes.
Now, he is suggesting that it is the opposite because he says the development is consistent with the predilection of the Attorney General to discontinue all cases which were being prosecuted against leading members and affiliates of the NDC.
Oh, I've just given you reasons why now I believe that Attorney General Dr. Kadine was right. I've just given you the reasons. I said, Godfred Dami was a political animal interested in convictions and not justice. Evidence emerged in the Ofune case. My senior Kujo, Samuel Kujo, who is popularly called Tom Sawyer, and Law Trust, was handling the matter. There was consistent evidence that the farmers who used the fertilizer of Sedu Abongo
Hello, Laji. Oh, we seem to have lost him on the line. I think that's 24 minutes past 8 here in the studios of Radio Gold 90.5 FM. Very interesting article written by Godfred Dami. Like I said, personally reading through, he did not address the issues which I expected him to deal with. It's about the quality of a case that he pursued. And I just responding to some of the issues that he's raised in that particular article. We're just landing on a note where he's suggesting. In fact, if you read that part, this is what Godfred Dami says. It's marks of an orchestration to clear the lady of a felonious act and highlights the growing perception of Ghana's current justice system. two sets of law for two sets of people. Equality before the law exists only in theory and not lived practically. The Sedina scandal is the closest Ghana has been to a reenactment of the Wuyume scandal. That's a suggestion by Godfred Yebo Adami that Alaji was addressing. Alaji.
Well, I didn't even realize I had lost you because I was consumed with what I was saying.
You're talking about the Seidu Agongo matter.
Yes, I was even consumed. You see, Godfred Dami is an embarrassment to this country. This country's motto. You know this country's motto?
Freedom and justice.
Yeah. And from what we are reading of his cases, and it's a twin veto, freedom and justice. Godfred Dami was not interested in that other virtue, justice. And then he takes a letter and writes what he's written. He should go and face the General Legal Council for coaching, trying to coach Japan to lie in court, for him to secure a conviction against Atufosan. He should go and face the General Legal Council through an ethical behavior that even the court chastised him for that unethical behavior. They only said that the court deprecated the fact that he didn't have the Attorney General, the first gentleman of the bar, in that judgment. So he should spare us our ears and eyes. And we was talking about State of Congo because he was bent on that, on getting Upuni into jail, State Congo into jail. He ignored all the evidence, including the fact that after they started the prosecution of Sedu Abungo and Opuni, contract for the supply of fertilizer was given to another person to continue to supply. And even in this case, at a higher price. That same fertilizer. So, just look at Atufosan. Ambulances were imported to this country. Those ambulances arrived in a shell form. The company, we lost elections. The company followed up to fix those matters. They said, oh, he ordered boxes and said they were ambulances. Meanwhile, you know that even the ambulances that you ordered when you came to power did not come fully conditioned. They had to come to fix those ambulances in this country. But they were just interested in showing Atufosan where power lies. Just like they were interested in showing Sedna where power lies. You say the woman has caused financial loss of 61 point something million when she has not paid any money under the contract. How is it financial loss? When the only payment that was done under that contract was payment authorized by her successor. They say the woman has caused financial loss. Are they misreading the law or what? Are they misreading the law? And then you say money for education and sensitization of loan takers across the country. Meanwhile, you refused or neglected to bring any of the regional directors of Maslock, any of the beneficiaries of the loans from the region to testify that at least I received a loan, I was part of the sensitization, but I didn't attend the sensitization. Or there was the director saying that, oh, in our region, even though we're part of the regions to be sensitized, but the activity does not take place in our region because I'm not aware of that activity. How do you prove such a case without the people, the beneficiaries, testifying that those activities were never carried out? But somehow they got a judge to complement their deficiencies. and shift the blame to the burden of proving that she organized those. Ghana is funny.
Well, Alaji, before we let you go, okay, so no, on that matter to land, the Attorney General himself has said that he will appeal. So
Attorney General was consumed by emotion. Just like when I was sitting with key members of the party, when we saw the news flash, and everybody, including myself, were shocked and surprised because it's too close to the time a settler arrived in this country and the beginning of a jail term. It's too close. So the coincidence was so funny that nobody, and I'm saying the emotions. But what I did was, when journalists called me, I refused to talk. I said, this matter is so shocking that you need to read and understand the reasoning of the court. So please, I can't talk on this matter because as a lawyer, and all the people I was sitting with, they also are a lawyer. What is this? I knew that, and you can't just go on appeal like you are walking into a chief palace for appeal. No, it is their processes. The processes, the procedural requirements. And when we talk about rule of law, it just means that there must be certainty and predictability, and that substantive law is as important as procedural law or adjectival law. And so I know there were processes, and you can pursue an appeal even in 6 months. Because there are a lot of things that you have to do. So, and China had come into this country less than 6 months. I said something must happen. Let me read the judgment. China, when I read the judgment, I said, this is seminal. This is groundbreaking. This is setting the standards for prosecution in this country. This is holding judges accountable, at least trial judges accountable. This is telling the Attorney General's office that what they did was not good enough. They said, and I agree with them, it doesn't mean that everything at Muslock was perfect, was kosher. But that is not how to prove a crime. You don't prove a crime by shifting the burden. And I agree.
I see. Because now we are expecting the Attorney General to file an appeal.
Oh, Attorney General also did not read. I believe that at time because he was doing this constitutional distance. And then when the matter came, so I'm saying that he was also consumed by emotions. I think so. Because if you read the judgment, yes, there could be other things that you can say about the judgment.
Okay.
But on the whole, the judgment is sound.
I see. I want to take your views on, okay, so on that day, was it that Thursday, the Attorney General also talked about the constitutional review process.
That was when he made the statement that he has directed that it was
yes. So I wanted you to, you heard some of the things the government has accepted, some which they have rejected, the white paper they issued. Was there anything that was said that day that you disagree with, in principle?
Oh, yes, so two things that were said that I disagree. And I disagree not because I don't support government, but I won't subordinate my constitutional right to expressing my view on the basic law of the land to the idiosyncrasies of some other persons. I won't do that. So I support government and I support the constitutional process, but I don't share in their view that we should extend the period of office of the president to 5 years. I don't share in that. That I heard that when President Kufuor was leaving office, in his last State of the Nation address, Kufuor said that and also gave the reasons that the Constitution Review Committee gave, Constitution Review Committee under Professor H. Prempe gave, and then the examples that the Attorney General gave supporting government's position. What is missing is that it doesn't talk about efficiency in government. It just talks about lethargy. And it's an attempt to extend the lethargy of government.
An attempt to extend the lethargy of government.
Yeah, the government just saying that 1 year is used in certain government, 1 year is used for campaign. So effectively, you are left with 2 years. That's lethargy. That's lethargy.
I see. So to you, a strong case has not been made out for that 1 year extension.
No one has spoken about efficiency. No one has said that government efficiency is low because we don't have efficiency indicators. And even if anybody had come up with that to extend, I would say no. President Mohammed's performance in his second coming has clearly shown that a government that is intentional, deliberate, and purposeful can do wonders within his first year in government. And that's about efficiency coefficient.
But if that same government that has demonstrated that then holds the opinion that we still need an extra year, should that not be convincing enough?
That's not convincing. That just goes to show perpetuation of rain. Doesn't show that doesn't answer to your question. What more are you going to do?
So that's the one point you disagree with.
That's one point. The second point is, and then they say, oh, I disagree, but it doesn't mean that I cannot be convinced. If they can convince me, because I'm also going out to campaign, and I'll campaign that I don't support it.
Oh, you campaign against this one?
I'll campaign against it.
I see. Then the second issue you were going to raise, and the second issue.
The second issue is the election of Metropolitan District and Municipal Chief Executives. Again, there's a misframing of the issue from my point of view. The issue is not executive accountability. The issue is not creating space for the people to determine who amongst those the president will nominate should be DCE. That's not, it's a misframing of the issue. The issue, as I understand it, is that people within local areas want an opportunity to hold their DCEs accountable. That's what I understand. So if the rubbish is not being collected, the DCE should not be able to not say that, well, I've not received the District Assembly Common Fund as an excuse. If their gutters are choked, the DCE, if there's crime in their local areas, the DCE, they are looking at governance at the decentralized level and who should be held accountable. If you say you are bringing governance to the doorstep, the recourse must not be to the executive as defined under Article 58 and 295 of the Constitution. Here, local government will mean the DCE, who is the highest political authority within the district, is the one the people want to hold accountable, not executive accountability.
I see. So two major things you disagree with, and I guess you will campaign against this one too. I see. Interesting. And then I want to conclude with you on this one. You served as Deputy Minister for Energy during the Mills regime, so Mills Mahama regime. The matter of toll, the revamping, in fact, under the former administration, the impression was given that it could not have been used for the purpose for which it was set up. Can you explain to us the thinking that goes into this? Because right now it sounds like an on and off relationship when it comes to the matter of tour. Mama comes, says it can be done. Somebody comes, says it should be a tank farm. What is the real issue with tour, as you remember? And should we be, what has happened? How big a deal is it?
So the real issue of tour is management. The vision has always been clear. And now when I was doing my LLM at Legon, that was part of the papers I presented. Tour was set up as a tolling station. At the time, Tour was set up. It was set up by, I think, Italians were in Ghana. That's why it was called Ajib. At the time that Tour was set up, Ghana did not have oil. We didn't have crude oil. But it was a tolling station. Government could bring crude and refine and sell. Or other nations in the Sahel could bring crude and then process, refine, and pay the tolling fees. There's a tolling station. And that's how it was working. Until the partnership ended, and then it changed to toll. Then Ajib changed into Goal. Then things started going bad. We could not, and then because Ajib left, and Ghana government took over completely, Ghana government was not reinvesting in the facility. The catalytic plant suffered major deficiencies, and that suppressed the oil. So there was no investment. So you had all pipes, all refining distance facilities, and so if you refined oil, you ran at a loss because most of the oil was lost to leaking pipes. So it is not that Tour is not viable. It's a question of management. And that's what President John Dramani is addressing. Investment has been done in Tour. Investment will continue to be done in Tour. Because what is being done now is just to demonstrate that Tour can be viable, can be efficient. But more investment will have to be done. But you need to start somewhere and perfect it with a vision, with a purpose. So that's what they're doing.
I see.
Yeah, because even at the time of MPP, an attempt was made to sell Tour.
Mm-hmm.
Someone was prepared to buy Tour.
Okay.
If Tour is not efficient, why would someone buy it? So they're going to sell it at a sing-song price to their own, so that person will reinvest and then be making money. Just like an attempt was made to sell the hotels. So that's it. That's what we define as state capture.
Thank you. Thank you for speaking to us this morning.
You're welcome.
I like Inusa Fuseini, Minister for Lands and Natural Resources.